In our leading story, Public Protector Mkhwebane has apologised in person to MPs on the Portfolio Committee on Justice for missing a scheduled meeting last week. Mkhwebane highlighted a letter she had sent to Committee Chair Mkhwebane on May 18th that explained why she had not delegated certain duties to Malunga. Committee Chairperson Mkhwebane personally accepted the reasons in the letter and suggested the committee accept the apology, but opposition MPs were not happy. DA Chief Whip John Steenhuisen has requested Justice Committee to set up a formal inquiry to assess Mkhwebane's fitness to hold office. The committee has resolved to reserve its decision on whether to uphold an inquiry into her fitness to hold office until she's had an opportunity to respond to complaints.
We must start from what transpired last week. To be honest, the mood last week. As a committee, we felt very much disrespected by the Public Protector and her office. We must be fair. The Public Protector herself not sending any delegation from office. And the late apology at around 5 o'clock, a day before the meeting, as you reported to the committee chairperson with due respect, we felt very much disrespected by the Public Protector.
I would like to again apologize for not being able to make it on the 6th of June. And I've tried my best to attend because we've already made the arrangements. I couldn't send my deputy because I thought those issues, especially the issue of the rules and the issue of the policy of the special advisor, required my special attention.
I equally felt disrespected, and I avoided going to the media. I was invited to the media to respond to what the Public Protector said, but I felt that I cannot go and debate with the Public Protector in the media. Family emergencies are different in degrees and in nature. Some of them may be so confidential that you cannot disclose. I'm prepared to accept that there was a family emergency. Emergencies don't give notice when they arise. We have a responsibility not to unnecessarily cast aspersions on the office of any head of Chapter 9 institution. And I want to agree with you, Honorable Swart, that it would serve our purpose for today that we proceed with the business before us.
I believe there's a prima facie case for this committee, or whatever other committee the Speaker ultimately determines, to recommend the commencement of proceedings to examine the fitness of the Public Protector to continue in office.
Well, joining us now on the telephone line is the DA Chief Whip, Mr. John Steenhuisen. A very good evening to you, Mr. Steenhuisen. Thank you so much for joining us this evening. Now, we were playing some bites earlier on, from your comments. Just give us a recap on the record currently, what the rationale is behind wanting an inquiry into Ms. Mkhwebane's fitness to hold office.
The inquiry that we're requesting arises out of the number of reports that the Public Protector has published and that have subsequently been completely discredited both in the courts and by legal experts. The most notable one in this instance is the Absa Bancorp matter, where the court set aside the findings of the Public Protector, but in doing so made very scathing comments about her conduct, the lack of procedure that she followed, the lack of professionalism, the lack of understanding of where her constitutional mandate begins and ends, and her usurpation of Parliament's authority to be able to pass legislation. These are all fundamental underpinnings of the separation of powers, which is one of the most basic legal principles that underpin the rule of law. For the Public Protector to be found wanting and to be exposed to mismanagement and misdirection in these instances is a fundamental breach of her understanding of the law. And we believe that this warrants an inquiry by the committee into her fitness to hold office, given the seriousness and seniority of the position that she holds.
Mr. Steenhuisen, just stay with us on the phone line as we cross over to Mr. Oupa Sekgalwe, who is the spokesperson for the Office of the Public Protector. Good evening to you, Mrs. Sekgalwe. Thank you so much for joining us this evening. Mr. Steenhuisen has outlined various reasons that they feel an inquiry should be held into the fitness to hold office of the current Public Protector. What is the response from the Office of the Public Protector?
Well, the Public Protector is indeed aware of those processes or attempts to have her removed from office. And frankly, she's of the view that it is prerogative of MPs to decide what is it that they want to do about her tenure. All that she is concerned about at the moment is to do her job in terms of the Constitution and the law, and that is to continue investigating alleged and suspected improper conduct in state affairs.
Now, Mr. Steenhuisen, just to come back to you, you've mentioned that there are some court cases against the Public Protector, which obviously bring to question her understanding of interpretation of the Constitution and certain things along that line. Now, we have seen, history has shown us, in fact, in some previous cases, situations where judgments were handed down and judges themselves were found to have made errors in the interpretation of the law, where judgments were reversed or reviewed or, set aside. But we never hear of judges actually having their fitness to hold office being called to question. Do you think that this should actually extend to the judges themselves as well, or should we just take whatever the judges say as the gospel?
Do not, but I mean, you're dealing with you're comparing fish and fowl here. Section 8 of the Constitution deals with the judiciary and judicial officers and the consequences for their lack of professionalism, and there's a Judicial Service Commission and a whole process there. What we're talking here is about Chapter 9 of the Constitution. Now, Chapter 9 sets out the creation of Chapter 9 institutions that were meant to partner with Parliament to defend and protect the Bill of Rights and also to support democracy in South Africa. Now, you're comparing judges with the Public Protector is not a fair or balanced comparison by any stretch of the imagination. Section 194 gives Parliament the authority to exercise oversight of the Public Protector. The Public Protector is accountable to Parliament, and Parliament is the institution that can inquire into her fitness to hold office on the basis of whether it's misconduct, whether it's incompetence or inability to perform her function. So, frankly, I think the analysis and the analogy between the judiciary and a Chapter 9 institution head in this matter it simply falls away.
Well, granted, let's also bring in the director of the Centre for Constitutional Rights, Phepelapi Dube. Phepelapi, very good evening to you and thank you for joining us. Can we hear a voice on the constitutional side of this argument that is before us, with Mr. Steenhuisen saying that based on certain court actions and certain reports that the Public Protector has actually released, they feel that she should be removed from office?
Well, I think there are certain, if one considers particularly the findings that were made by the High Court, and if you also consider the manner in which she conducted herself in the Absa CX litigation, I think there are quite compelling reasons to remove her from the office. But of course, we need to balance that up against some of the work that the Public Protector has been doing. So, for example, the fact that in her report before Parliament today, she mentioned that the office has finalized over 20,000 cases and that she's embarked on a nationwide project in terms of which she's trying to bring the Office of the Public Protector to make it more accessible to the ordinary person on the street. I think in her reference to these kinds of people, she calls them the Gogodlamini. So in that sense, it would be really important going forward to balance all that up against how she has conducted herself in these two important pieces of the litigation.
And just for the benefit of our viewers, could you talk us through the process for actually removing a Chapter 9 institution head from their seat?
Well, in terms of the Constitution, in order to remove a Chapter 9 head from their position, first of all, it's important that the committee that's before Parliament, and in this specific instance, that's the Committee on Justice and Correctional Service, that the committee itself agrees to remove her. And that can only be done for 3 reasons. So on grounds of incompetency, on grounds of misconduct, or on grounds of a serious violation of the law. So it's important for that particular committee to first of all agree on at least one of those terms. And thereafter, the committee can then pass this agreement on to the National Assembly itself. And if the National Assembly decides to adopt a resolution by a 2/3 majority, then the president has no option but to remove the public protector from the office. But of course, on that point, I just want to stress the fact that it's a 2/3 majority, and that obviously means that it's important for a public protector to have secure tenure in office because of the position that she occupies. So it's just important that conversely it becomes very difficult to remove her from the office. So going forward, the Portfolio Committee on Justice and Correctional Service needs to come out with very cogent reasons as to why she needs to be removed from her office.
Well, just coming back to Mr. Steenhuisen, do you believe that there are some third forces influencing the public protector and the way in which she carries out her duties?
I'm not sure, and I mean, that's a matter for speculation. I prefer to deal in facts, and the facts that are laid before the committee today were the findings of the High Court in both the Murphy and the Gauteng full bench decision, which found her shortcomings and found her acts of omission commission so egregious and so fundamentally flawed that they put in place a punitive personal cops order against the public protector. Now, this is an unprecedented move by the court and shows the complete lack of understanding and the serious nature of the acts of omission and commission by the public protector. There's speculation around her influence from the SSA, but those certainly were not part of the discussions today. What we put before the committee very clearly was facts. And while she has appealed some of those, the appeal is very narrow in terms of only appealing against the personal costs order and the various clauses. She doesn't take issue with the fact that the Speaker submitted an affidavit and that affidavit and submission was upheld, that she had encroached on Parliament's exclusive authority, that she had acted in an unconstitutional way, that she had acted in an undemocratic way, and that her release was not proper release. And so these are solid factual findings. So I prefer not to speculate in a matter when one motivates for the fitness to hold office in speculation, but to rather deal in fact, and that's what we did today.
Now, Mr. Zakhalo, just coming back to you, can you just respond to Mr. Steenhuisen's facts that he has put forward?
Well, just to emphasize what he just said, that the public protector has indeed indicated today in Parliament that she has petitioned the Supreme Court of Appeal because she's aggrieved by some of those or by those judgments, and she has also considered going to the Constitutional Court to deal with that. But one other thing that does not sit well with her is that she is being judged on the basis of only 2 reports, when she has released 48 other reports, finalized 21,000 out of 25 matters that she has dealt with in the 20 months that she has been in office. And those are not just statistics. She demonstrated by citing real examples of the impact that her work has made in the lives of South Africans, both the grassroots people as well as in matters that involve governance at the highest levels of government. You will recall that now, as we speak, we have about 2 former ministers who are out of the cabinet as a result of the work of the public protector. So sometimes when people criticize, they don't recognize the good work that you are doing. They just push their agenda so they can achieve whatever they want. But as I said, the public protector is not worried about all of this. She's focusing on doing what she has been appointed to do, which is to ensure that there's good governance in state affairs and that there's quality service delivery to the people of South Africa.
Now, Mr. Steenhuisen, would you agree with Mr. Sakhalwe that the Public Protector has actually done some good while she has been in office?
Well, it's difficult to say, but I would start off by saying that Minister Van Rooyen and the other minister's departure from the cabinet had absolutely nothing to do with the Public Protector. It was the fact that the presidency changed hands and they found themselves in the wrong faction. So I think for the Public Protector to start claiming a credit for that is actually trying to claim an easy victory that doesn't belong to her. I'm actually quite surprised, and what we will be doing is going with a fine-tooth comb through these 20,000 settlement claims, because if the Public Protector is unable to get the basic grasp of the law right in terms of her constitutional mandate, heaven knows what these other findings and that have arrived at. And so we will be looking very carefully at all of them to try and determine whether in fact the law has been applied, the Constitution has been applied, and her mandate has actually not been exceeded. When she gets it spectacularly wrong on issues like the Bancorp matter, when she behaves in a biased manner, when she behaves in a manner that is unprocedural and unconstitutional and undemocratic, I think that it actually undermines the fight against corruption in South Africa nationally, because she undermines the credibility of that office and calls into question any other reports that she may release in future, and makes it an easy target for the corrupt and people who have perhaps done wrong to move to discredit and set aside. She should be treating each of her reports as a fortress, buffeted and protected completely by the law, which should be applied absolutely to the letter. That has not been the case with this. There's been other findings that she's made this week as well, which are also going to be challenged, which are quite spectacular somersaults of both the Executive Members Ethics Act and the Constitution. And I've no doubt that those themselves are going to expose even further lack of understanding of mandate and understanding of even the most basic principles of the separation of powers and the rule of law.
Closing comments then, just starting off with you, Phepelani Dube.
Well, I think if one considers her particular conduct in the Bancorp matter and off of the back of the comments that were made by the judges, I think those were very strong comments that were directed to the Public Protector. And of course, it's also telling that the Public Protector is appealing those cases, but only appealing the cases insofar as it relates to the fact that she received a personal cost order. She's not necessarily appealing the merits. So in that regard, one would argue that what the court found against her still stands. And I think even though the Public Protector has, by probably the spokesperson's own admission, done a lot of work and finalized a lot of cases, I think it still comes down to the fact that there were monumental mistakes that were made, and there were elementary sort of mistakes, and it would be very difficult to convince any other person in the legal fraternity that indeed the Public Protector is at the very least aware of the powers of her particular mandate. But of course, as I mentioned previously, it's very important to balance that up and weigh that up against the other work that the Public Protector's office has been doing. And of course, I also want to make the point that it's also important to also have clarity on the nature of these 21,000 cases that have been finalized, in terms of going beyond the figure that's being floated out, in terms of breaking down that number and asking, what does finalization mean? Was the particular claimant happy with the final findings of the Public Protector? And also, what was the nature of the complaints? I think we all heard the spokesperson in a radio show yesterday basically admitting the fact that the Public Protector investigates any cases, any and all cases that are brought to her office, even if those cases may not necessarily be within the realm in terms of the law of the Public Protector's office. So these are the kinds of questions that we need to find out. Of those 21,000 cases that have been finalized, are they all strictly speaking within the realm of the Public Protector to exercise? So I think those are the questions that we need to be asking forward. But of course, it's obviously very important to remain balanced, it's important to remain impartial, and it's just important for us to be guided by the dictates of the Constitution at the end of the day, bearing in mind the importance of the role that the Public Protector's office plays in South Africa.
Mr. Steenhuisen, your final words?
evidence to initiate the inquiry. Nobody's saying that the public protector is guilty. All that we're asking for is for an inquiry to proceed into her fitness to hold office based on the findings of these particular judgments. We believe that Parliament should not be derelict in its role. It's already been criticised heavily by the courts in the past, most notably in the Nkandla matter, for ignoring its mandate to hold organs of state accountable to it. Chapter 9 institutions, by virtue of the Constitution, are accountable to Parliament, and Parliament has the oversight authority over them. So far from, as the Public Protector said now on 2 public platforms, Parliament interfering in her work, this is Parliament's responsibility to hold her accountable. And we must do so to ensure that we give effect to the mandate that's been given to us by the people of South Africa, electing us to Parliament, to do our duty to ensure that these institutions act correctly and properly. We believe there's sufficient evidence that in the Public Protector's case, she has a case to answer and this should trigger an inquiry where a full exposition of many of the things that we've spoken about this evening can be looked into in greater detail, and then a determination made whether she should be removed from office or not.
And lastly, Mrs. Khalwe, from you.
Yes, from my side, I would just like to say that people must understand and remember that the Public Protector is not new to this office. She has worked for the Public Protector, the institution, for 5 to 6 years as a senior investigator, went on to head the provincial office of Gauteng, and went on to beat dozens of other hopefuls for the position. That shows that this person knows and understands her mandate, unlike what her critics are saying. And then going forward, she will take note of whatever is happening in Parliament, but she will not allow that to distract her from doing what she's appointed to do, which is to enforce accountability on the part of state functionaries, while ensuring that there is a good governance as well as quality public services delivered to the people of South Africa.
Well, thank you very much for joining us over the phone lines to Mkhwebane Dube, the Centre for Constitutional Rights, and also Mr. John Steenhuisen, DA's Chief Whip, and Mkhwebane Khalwe, the spokesperson for the Office of the Public Protector. Moving on,